All right, Mr. Kendrick and Mr. Weinstein, good morning. All right, Mr. Huey and Mr. Matthews Jr. and Sr., good morning. All right, Mr. Nichols and Mr. Lamar, Mr. Garner, I should say, good morning. All right, Mr. Ryan and Mr. Williams, good morning. All right, Ms. Hilton, Mr. Atkins, Ms. Love, and Mr. Brown, good morning. All right. Okay, Ms. Renard, who's that interloper sitting to your left? And why was I not told anything about other people in my courtroom, Mr. Steele?
And good morning to you, sir. Your Honor.
Oh, don't be trying to get over that, man. You're already in hot water. So who do I have the pleasure of now being with you?
Your Honor, sitting next to Mr. Ryan and Ms. Renard is Haley Haltwanger, Haltwanger. She is a second-year law student at Georgia State University. I've had the honor of working with Ms. Haltwanger approximately 2 years. She's a fabulous lawyer, representing the next generation of lawyers, and with the court's permission, we'd like her to sit at the table. Mr. Adams means no disrespect to the court or Mr. Williams or anyone. He is not going to be here today. He is actually in another court for the week on a trial. So can never replace Mr. Adams. I'm not trying to do that, but with the court's permission, that is who is in your honor.
Okay. Mr. Williams, you okay with that? Okay. All right. Okay. All right. Mr. Bean outside?
Yes, sir. He is, Your Honor. Before we get started, I'd just like to ask if the court would allow us an opportunity to look at some certifieds that Mr. Steele indicated he has. He indicated he would show us his certified. And the court came in right before he had an opportunity to do so. So before we bring Mr. Bean, could we just see a copy of the certified? See the certified itself.
Sure. You all can look at those.
And Your Honor, would the court like for us to bring Mr. Bean in before I look at the certifieds?
No, why don't you accomplish that, and then we can bring Mr. Bean in. I just want to make sure he was here, that's all.
Okay. And is it?
That's not exact.
Thank you, Your Honor. We have been able to look at a copy of the actual certified copy of 14 SC 130460, and based on information that Mr. Steele shared with me just now, I don't want to speak prematurely, but it appears that he also has some indictments that he intends to use, and I move in limine that the court preclude Mr. Steele from any attempts at impeachment or improperly introducing indictments that are not certified convictions of this witness or any other. based on the information that he just gave me when I asked to see the certified copies of conviction, he has only given me one certified conviction for Adrian Bean, and that is for Fulton County Indictment 14 SC 130460.
Okay, so there's no argument about the certified, is that right?
Correct, there's
Okay,
no
all right.
argument about this.
And then what about the uncertified or do we, is that what you're asking me to,
Yes.
or to pose or weigh in on?
Yes, because I've just been told that Mr. Steele has copies of indictments. I don't know.
You have certified copies of those convictions, sir?
And good morning again. As I told the district attorney's office, they're certified copies of charges of an indictment, not convictions. I told the district attorney I was not planning on seeking to admit them now, but they may become ripe. What happened in two different cases, if you want to know, is Mr. Bean was charged, serious crimes, armed robbery. I may be a little off here, but armed robbery, trafficking, marijuana, something to that effect. And the cases were dead docketed. Under Ridley, which is RIDLEY versus State, it's 368 Georgia Appeal 481. Your Honor, that's 890 Southeast 2D 385, 2023 case.
Bless you.
Is 157C the conviction of Mr. Bean? Appropriate time. So I have to give you a date of number. I'm not sensitive about any of it twice. That's mine. If I don't need to use it,
You can just reference it as long as the copy is the exact.
but that's 157. Okay, thanks. Can I see 157C, if you don't mind? Should be the certified. How may I approach the?
You may, sir. Still Westlaw don't want to cooperate with this morning, but that's all right. Go ahead, sir.
I have a hard copy. I only have one, though.
That'd be great. Thank you.
I apologize. I only have one
All right.
hard copy. So, 481 is. May I approach, Your Honor?
You may, sir. Thank you.
May I, Your Honor?
You may.
Okay, so what the court in Ridley explains is that the confrontation clause, it's in the 8th paragraph, Your Honor, it's on page 2, and I've explained that to Mr. Brown of the state. The confrontation clause of the 6th Amendment guarantees to the accused the right to inquire about a witness's pending criminal charges in an effort to show that the witness has a possible bias, prejudice, or ulterior motive that may influence the witness's testimony. Whether the witness is testifying pursuant to a deal with the state is not crucial to the right to conduct such a cross-examination. And then, Your Honor, on the 2 items that I may not use, but that the state was inquiring about, and I just put them on notice of it. I gave them a thumb drive today, and I told them, is Seals, S-E-A-L-S versus state, 311, Georgia, 739. And it's in Division 3B, as in Barry Bravo, and specifically, Your Honor, if I may have one copy, may I approach?
Yes.
Sorry. A case is that Seals, that actually determined it. That's our case in Georgia that made this, that a dead docket case remains pending. So because the cases are dead docket, not null pros, they actually are pending with Mr. Bean, could be brought back on a live docket with the court's permission. The reason I said I gave it to the state, I just gave them everything. The reason I did that was in abundance of caution that it came up and I felt needed to do it. So I want to be courteous as you told me to do, and you told everyone to do. So that's why I did it. But as I told the state, I'm not really planning at this point to use them. They are older, Your Honor. I wouldn't be using them for impeachment. I think I'd be barred by the 10-year rule unless you made a finding that it was critical. But I can impeach with Mr. Bean with other convictions, so I can't really argue that it's, quote, critical to impeachment of this witness. I'm not saying the witness is not critical, but, you know, I have other manners and means to impeach him, I believe.
But he might open the door as to other things.
Exactly. And that's why I just did it at abundance of caution. But I'm not really there in my mind, but I just wanted to provide the state. I also gave them about 6 this morning. I gave them about a 10-minute interview that, you know, Honorable Investigator Jimmy Martin Jr., which is, it's really James, J-M-E-S, Martin Jr., and I did with Mr. Bean. It was Sunday, January 22 of 2023. And I will be using that for impeachment because, respectfully, I know it's a jury question, but I believe he was not straightforward on his testimony on direct last week. And it's also a prior inconsistent statement, but it also goes to trial testimony under oath, which can be impeached at all times. So I gave that to the state early this morning. It's only a 10-minute interview. Okay.
Your Honor, 2 things I want to point out. Mr. Steele has had apparently this interview since January 22nd of 2023, if I heard him correctly. He did just send it to us this morning at 6 o'clock. That part is okay. The part that is not is that he would have to confront and lay a foundation for the playing of any audio recording that is out of court. Any such recording is barred as hearsay under 24A801 unless there is a, unless he can establish, unless he can confront, unless he can somehow establish that there is an exception to the hearsay rule for that particular statement. Secondly, the indictments that he has given us copies of, I believe for no reason should be allowed because they are way more than 10 years old. They are from 2011. He has, in addition to the certified for 14 SC.
Don't think that's the issue. He's just bringing them to the attention of you and the court so that if your witness should open the door as to him, I would make some certain probably findings at that point in time.
Yes, Your Honor, I understand. I, of course, do not intend to inquire into the defense's strategy, but for the sake of arguing that somehow there is a reason that this witness would want to cooperate with the state, that is what Ridley is intended to stand for. They would be able to show through open cases a witness's reason for wanting to cooperate with the state. And again, I would argue that these three, 11SC, 06SC, and 13SC cases for which Mr. Steele provided us indictments this morning are not permissible under any of those circumstances. And I, before he even tenders or walks to the witness to attempt to show them or even mentions them in front of the jury, I would ask that the court require Mr. Steele to, at the very least, outside the presence of the jury, tell the court what he intends to use them for. Because otherwise, once the toothpaste is out of the tube with respect to some impermissible document or impermissible item he wishes the jury to know about, it's already out. So I would ask that the court preclude him from even mentioning, tendering, or asking the witness about any 11SC case, 06SC case, or 13SC case that he has given us a copy of an indictment of for any reason until he, outside the presence of the jury, tells the court for what reason he intends to try and introduce it. Because again, we would argue that it's impermissible. It would be, as he stated himself, it's not permissible impeachment evidence. It is over, they are all over 10 years old. They're all closed cases.
But, well, they're dead docketed, right?
Okay, that's fine.
They're dead docketed. These two cases are apparently on the dead docket, right?
So the 11SC case and the 06SC case are either they're dismissed for all intents and purposes. But the point is, and the 13SC case, let me make clear, I believe that one is actually states 157C. I believe he was sentenced for that one. So as far as if this is the same one that we've already introduced, we have no objection to that being used. But the 11SC case and the 06SC case were dismissed against Mr. Bean well over 10 years ago. And
Okay, all right. Were they dismissed? How were they dismissed? Were they placed on the dead docket? Were they null pros?
we don't have a
there's
certified
verdict?
copy of the file. So all that we have is a copy of an indictment with nothing more from the file from Mr. Steele.
So how do we know? How do we know how it was resolved?
Because the copy of we don't know exactly how it was resolved beyond what Mr. Steele has shown us, which is the indictment itself with the word as to Adrian Bean, the counts are placed on the dead docket in July 2011.
Okay, well, they're
And
placed
I
on
don't
the.
know.
Just stop. If they're placed on the dead docket, that case still is technically open. It can be prosecuted, and that's what the case law seems to
The
indicate.
statute of limitations has run on these items, and we cannot. We've dead docketed it in 2011. We can't bring it back.
Your Honor, the statute of limitations is satisfied once the indictment is returned in open court by the grand jury. There's not a statute of limitations issue with a dead docketed count.
Again, Your Honor, since Mr. Steele has indicated that this issue is not right, my only request of the court is that before Mr. Steele mentions it, he, at least outside the presence of the jury, tells the court for what purpose he intends to try.
Let me ask a question. Mr. Steele, do you have some basis to believe that the state has offered Mr. Bean a deal, or has indicated that they're not going to take these dismissed cases off of the dead docket, or what's your theory of how you might confront the witness?
He would, no, to answer your question directly, no.
Okay.
I don't have any reason, good faith belief that the state is saying it's coming off the dead docket, but under Ridley, R-I-D-L-E-Y, that's not the issue. That's exactly why I gave you the case. It goes to the state of mind of the witness who is testifying, and the jury makes that determination.
The state of mind as to how?
Because what
Really doesn't say that.
Yes, it does. If you
Where in really does it say that? Point to the page. I want to see it.
Started the 8th paragraph, which I think is on the 2nd page, Your Honor, and then go to the 3rd page. And it says in the very top left-hand, I'm going by my memory, but top left-hand corner, it should say whether the witness is testifying pursuant to a deal with the state is not crucial. I'm going by my memory.
Yeah,
the
that's
right.
pretty close. Okay.
To the right to conduct such a cross-examination. So it's a pending charge. This isn't about a deal. This isn't about conviction of 10 years of age. I just, God willing, straight with the court. I'm just telling you, I understand that if it was a conviction, I wouldn't be able to use. I have other convictions for him, but they're over 10 years of age. I'm not trying to get those in because I don't think it's right to ask this honorable court to make a balancing test.
So you're saying he's still facing charges,
Exactly.
and that's what you want to ask him about?
Yeah, that's all that issue is.
All right.
And it has nothing to do with the statute of limitations. It has nothing to do with a conviction. I don't know. I'm just doing what I think lawyers should do. I'm just being straightforward.
Your Honor, under 403, given that these are dead document charges from 2011, and I don't believe that Mr. Steele or Mr. Williams has any good faith basis to argue that under Ridley, he should be allowed to introduce this 11SC case and this 06.
That's what Ridley seems to indicate, and it tells me under 403 it's an extraordinary remedy which should only be used sparingly. So if he wants to ask him about he's facing charges, he's technically still facing charges, and he would be permitted to do that. If it comes up, okay? So, but right now I would let him do that.
Well, with that being said, then I will do it.
Your Honor,
Okay.
under Ridley, when the court says that he is facing charges,
He's still facing charges. He's got a dead docket. Dead docket stops the statute of limitations. It's still open case. How many employment times have witnesses or other people faced dead dockets and then because the same thing because it's still an open case? That's my ruling. Can we move on?
yes, Your Honor.
Okay, all right. If it comes down to it, so yeah, he's got a good faith basis. So if it comes down to it, he can ask those questions. All right, anything else?
Not on behalf of Mr. Williams.
That's all, Your Honor.
Okay, all right. Sergeant Ingram, can you summon our jurors for us, please?
And Your Honor,
Madam.
Mr. Steele will not be attempting to claim any hearsay. He won't be tendering any, is my understanding, without laying any foundation for that. Right.
Yeah, come on. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, good morning. Good morning. All right, you sound good. Okay, all right. Ms. Love, I believe that we still had Mr. Bean with us, so can we summon him, please?
Yes, Your Honor.
All right. Mr. Bean, good morning. Come on up again. All right, sir, you're still under oath, okay?
Yes, sir.
All right, thank you, sir. All right, cross. Mr. Steele?
Thank you, Your Honor. You were released from prison in approximately 2017. Is that correct?
Yes, sir.
And since you've been released from prison, you have been gainfully employed. You've been working, right?
Yes, sir.
And you work for, I believe, currently, and if I'm wrong, just tell us, for the city of Atlanta, is that right?
No, sir.
Who do you work with currently?
I'd rather not say who I work for, sir.
Okay, what do you do currently for a living? How about that?
I'm a foreman.
And explain what type of foreperson.
Foreman.
You said a foreman.
A supervisor.
Okay, for what type of work?
Traffic control.
Okay, traffic control. I'm sorry, I'm having a hard time hearing you. Traffic control?
The traffic control.
Okay. And how long have you been doing that?
I really can't recall.
One more time.
I can't recall, sir.
Has it been more than 2 years?
Yes. Yes, sir.
Okay. And are you working other jobs as well currently?
No, sir.
All right. With regard to your testimony last week, Thursday and Friday, you said a lot of, I don't recall 2013. Do you remember something like that?
Yes, sir.
And I think you explained or tried to state that that was a bad time in your life, you blocked it out. If I'm misstating that, just correct me.
You don't recall anything from 2013, sir.
And why is that?
I just don't recall. I don't remember. Just don't recall, sir.
Do you remember things in 2014?
No, sir.
No? Yes or no?
No, sir.
2015?
I don't recall, sir.
How about 2016?
No, sir.
2017?
I just remember what I need to remember in 2017.
That's after prison, is that what you're saying?
I mean, I was released from prison in 2017.
And is your memory good after 2017 released from prison? Do you remember whenever month, I don't know the month, you're released from prison, you remember that? Is that what you're telling the jury?
Yes, sir.
And you remember then 2018?
Your Honor, I object as to vague. That's a broad question and not specific
Okay,
enough.
all right. I'll sustain the question. Just rephrase, Mr. Steele.
Do you have a memory of things you did in 2018?
Again, objection, vague.
I'll let him answer the question. I'm all over the question. You can answer it, sir.
2018. What I'm remembering in 2018.
You don't?
What am I remembering in 2018, sir?
Anything, where you were working, how about that?
No, I don't remember where I worked in 2018, sir.
Okay. Do you remember being home in 2018, not incarcerated?
Yes, sir.
All right. How about 2019? Same question.
What am I remembering?
Same question.
Every year you asking me what am I remembering for every year that you ask me about this certain type of year. That's what I'm trying to get you to understand.
Answer my question. Do you remember where you were working in 2019?
No, sir.
Were you working in 2019?
I don't remember.
Were you living free in 2019?
I'm free.
Were you living with your wife in 2019?
I've been with my wife in 2019.
Same question. It's 2020. You remember that year where you were working?
I've been doing the same job for some years now, so it'll run into all that. It's 24 now. I've been working by 7, 8 years now. The working part is going to be what you're asking me about, sir.
And you remember that in 2020, right? Yes or no?
Yeah.
And 21, same question.
Okay.
Remember
Yeah.
that?
I remember my work 21. I remember my work 22. I remember my work 23. I remember my work 24. This year right now, what we're looking at.
How clearly do you remember 23 and 24 years? This year and last year.
Not too good, but
I can't hear you.
Not too good.
Okay. Mr. Bean. You remember being convicted of what has been marked as State's Exhibit number 157C, as in Colette or Charlie, that you identified last week. Do you remember that?
No, sir. I don't know.
Okay. Your Honor, with the court's permission, may I show electronically 157C in Colette? And Mr. Kokomo, if he can help me out. It's already in evidence, Your Honor.
Yes, sir.
It should be on the screen. You can look behind you or right next to you in a moment. And I want to go through this with you. Okay, Mr. Bean, what's on the screen is been already admitted on March 1, 2024. This is the Superior Court of Fulton County, State of Georgia versus you. You see that on the left-hand side of that first page?
Yes, sir.
And you see where it says filed in the office of the Deputy Clerk of Superior Court, Fulton County. It gives the date of October 15, 2015.
It's gonna still be the same.
I can't hear you.
It's gonna still be the same. I seen this paper last week. The same paper Miss Love showed me last week.
I just cannot hear you.
Friday. It's gonna be the same thing. I seen this paper before.
Answer my question. Do you see it says October 15, 2015, filed in the office of Deputy Clerk, Superior Court, Fulton County?
Yes, sir.
And you see in the next column to the right, there's a rectangle and it has your date of birth, June 22, 1979. True?
True.
Okay. And then if you go down on that page, with Mr. Kokomo's permission, you see it lists certain charges on the left-hand corner. You see that? Left-hand side? It goes from 1, 2, 3, 4, 5, 6, and then it skips to 9. You see that?
I see it.
Okay. And then it says in the disposition, you see 2 columns over, after it says charge, and then you see disposition.
Yes, sir.
And on count 1, it says guilty Alford. Right?
I don't know.
Do you see it?
I don't know.
I can't hear you.
I don't know.
Do you see it? Is what I'm
I can't
asking.
really see it.
Yes?
Okay. Where you think it? Yes, sir.
Okay. And then it says for the sentence, 10 years to serve 3 years. That's in prison, right?
Okay.
Balance probated 7 years, right?
Okay.
And then it says concurrent with, and it gives another indictment number. You see that?
Okay.
And that's indictment number 14 SC 130460, which we're going to discuss in a moment. All right? Okay? Yes?
Aye.
All right. Now, this is October 15, 2015, and the total sentence here is 10 years, right?
I don't recall this.
Well, that was your sentence.
I don't recall this, sir.
Okay. This is the same document you recalled last week on the 1st of March, right?
But I still didn't recall it.
All right. Count 2. You see on the left-hand side, count 2, it says aggravated assault against a police officer, vehicle on vehicle. You see that? You see that?
Yeah, I don't recall none of this paperwork right here, but you're showing me, though, Mr.
All right, well, it's in evidence, so we're going to go through it. Again, you pled guilty under Alford, right? And the same sentence, 10 years, is total sentence, 3 years in prison, the balance is 7 years on probation to run concurrent with count 1, okay? That's what it says, right? Yes or no?
Sir, you got to answer the questions, okay?
Yeah, I guess it's on the screen. Yes, sir.
Count 3 is again aggravated assault against a peace officer, and again guilty under Alford, 10 years to serve 3 years, balance 7 years on probation, concurrent with count 1, right?
I never pleaded to this.
All right, we're going to talk about it. We'll go through the whole document. The next one is count 4, 5, and 6, and that's armed robbery, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony, and all those were no pros or dismissed. You see that?
Yes, sir.
All right, and then the last one is count 9, fleeing or attempting to elude, misdemeanor, and again, guilty under Alford, 12 months to serve, concurrent, run at the same time as count 1. That's what it says, right?
That's what it says.
All right, let's go to page 2 with Mr. Kokomo's permission. And these are the terms of the sentence summary. You see that right there where Mr. Kokomo stopped? You see in bold it says sentence summary.
Sentence summary, yeah.
Okay, and defendant is a word used for somebody charged with a crime, right? You know that?
I didn't know that.
Like a plaintiff is a state, or a defendant is a person charged, or in a civil case. Do you know what I'm talking about?
No, sir.
No? Okay. Well, it says the defendant is a judge guilty. Excuse me, I'm in the wrong place. The defendant is sentenced for a total of 10 years, with the first 3 years to be served in confinement, the remainder to be served on probation, right? Then it says, or, and that it's not checked, to be served on probation. So you were sent to prison, right? You see that?
Man, you say so.
Well, that's the prison you're talking about with the jurors that you said you got out in about 2017, right?
Yes, sir.
All right. And then if you go down to the next line, the defendant, which is just the way it's termed, but you are to receive credit for time served in custody as determined by the custodian. That's the Department of Corrections for the state of Georgia, right? You see that?
Yeah.
And then on the next one, which is box 2, it's checked. Upon the service of 3 years, the remainder of the sentence may be served on probation, provided that defendant shall comply with the conditions imposed by the court as part of the sentence. And then it goes through general conditions of probation and special conditions underneath. Okay? You see that?
Mm-hmm.
All right. And then Mr. Kokomo can scroll down, and it's checked, or X, number 2. Probation supervision fee is waived for the first 6 months after release. You see that?
Yeah.
And then on the next page, it says special conditions of probation. And you waive your 4th and 5th Amendment rights, meaning you have to answer questions. Right? Do you know what the 5th Amendment is?
Your Honor, I object as to the commentary about having to answer
I
questions.
sustain the objection.
Do you know what the 5th Amendment
Your
is?
Honor, I'd ask
I
that.
sustain the objection.
For the 5th Amendment? Ask him if he knows what it means. Okay. You waived your 4th Amendment and 5th Amendment rights. You see that?
I'm looking at it.
Okay. And then maintain employment, undergo regular random drug screens, obtain a GED, and then back to that court if your probation is going to be revoked. You see all that?
I'm looking at it.
And revoked probation means you go back to prison instead of being out on the street under supervision of a probation officer, right?
I guess so.
You don't want to go back to prison, do you?
I mean, what do you mean?
cannot, I'm
What do you
asking,
mean, sir? Do I want to go back to prison?
you don't want to go back to prison, do you?
If I had to go, I would. I went to prison.
Do you want to go back?
I've been to prison before.
Did you enjoy prison?
Counter objection.
I sustain the objection.
I mean, I did mine. I did my time.
Underneath that, if Mr. Kokomo comes down,
When was the last time I took a road trip? How many national parks could I hit in 2 weeks? What about hotels? Wait, hey, Erica, how much am I spending on travel?
When your questions about life turn into questions about money, there's Erica, the virtual financial assistant to help you spend, save, and plan smart.
you hired a lawyer, if you go down a little more, named Ed Adams. You see that by employment?
Yes, sir.
Okay. And then that court was the Honorable Judge Downs, who sentenced you. You see that?
Yes, sir.
Now, Mr. Williams never paid for any of your lawyers, right?
No, sir.
He never made any bond for you, right?
No, sir.
The next page of this document, 157C, as in Colette, Charlie, keep going down, is the indictment. I want to go through the indictment with you. Okay. If you go up a little bit. Perfect. Thank you, Mr. Kokomo. Go down just one more to get count 9. Now, on this indictment, Mr. Bean, in State's Exhibit number 157C, as in Colette, Charlie, you see the indictment number there in the center, written in 13SC 12-2087. You see that?
Yeah, that's what it says.
And it says State of Georgia versus, and the first person is you, with count 1, 2, 3, 4, 5, 6, and 9. Same counts that we just discussed on the sentencing page. You see that?
That's what it says.
And then you have the next person charged is Walter Murphy. You see that name?
Yeah, that's what it says.
And he's the same Walter Murphy that you discussed earlier, according to, you said you didn't recall, but he was referred to by the Honorable District Attorney as DK. You remember that?
No, sir.
All right. And he is also charged with you in count 1, 2, 3, 4, 5, 6. Mr. Murphy's charged in count 7, but also in count 9. You see that?
That's what the paper says.
And then the last person is Frederick Medina, which is Medina, Prothro, Prothro. You see that?
Yeah, that's what it says, sir.
And Mr. Prothro is also charged in similar counts as you, but count 8. So he's charging 1, 2, 3, 4, 5, 6, 8, and 9. You see that?
I guess that's what it says.
And this indictment was filed, if you go down a little bit, Mr. Kokomo. Originally, October 1, 2023. You see that?
It says 13.
You see that? I couldn't hear you.
I said it says 13.
Okay. And then, for Walter Murphy, you see where he pled guilty to count.
Objection, Your Honor, as to having this witness testify about someone else.
I sustain the objection.
The documents and evidence.
It doesn't make a difference, Mr. Steele. That's a proper objection. I'm sustaining it.
All right. Let's just, before we leave this page, just go up a little bit, Mr. Kokomo. Show the jurors where Jeffery Williams is charged, along with you, Mr. Prothro, and Mr. Murphy in this indictment.
You show me.
I cannot hear you.
You can see it clear as day. It's on the paper. You show me. He's not there.
He's not there. Now, October 1, 2013,
the return of this case, that is after you spoke with Detective Quinn at the City of Atlanta Homicide Office on recording on September 17, 2013. You realize that?
No, sir.
All right, if you can scroll down, Mr. Kokomo. And Mr. Bean, this is the next page. And you see in the top, I'll just talk about you. So I'm excluding the first column, Mr. Prothero, the second column, Mr. Murphy. We're going to the third column to the right on the top. You see where you originally pled not guilty with your lawyer, Ed Levance Adams, and your signature. You see that?
Yes, sir.
And that's, it says October 29, 2013. You see that?
Yes, sir.
And then if you go down, and it's on an angle on the side, or actually it's on the center right. You see where it says Adrian Bean with your middle name? You see that in the center, kind of right?
Yeah, that's what it say.
And you see there's a check mark. You pled guilty under Alford to the indicted offenses in count 1, 2, 3, and 9, like it says on the first page of 157C. You see that?
Yes, sir.
And that's October 1, 2015 now. So it's 2 years and 3 weeks after September 11, 2013 that you're resolving this case. You see that?
That's what the paper say.
One more time.
That's what the paper say.
Okay. And then the other counts, if you look kind of on an angle, as to Adrian Bean, count 4, 5, count 4, 5, and 6 is null pros. Null pros means dismissed, just like was on page 1. You see that?
No, I don't see it.
Mr. Kokomo, can you just orient Mr. Bean? You see where that pointer is?
Okay, sideways, huh?
And that's also October 13, 2015, right?
I can't really see it.
Yes?
I can't really see it. Yeah, I see it, man. At the bottom.
You see it? Yes?
I say yeah.
All right. The next page of this document is the actual charges that you were facing along with Mr. Plethro and Mr. Murphy. And you see the names of the grand jurors in the center. It says a grand jury selected, chosen, and sworn for the county of Fulton to wit, and they charge you. You see that?
That's what the paper say.
And count 1 charges you, Mr. Murphy, Mr. Medina, with the offense of aggravated assault against a peace officer for that the accused, that's you, and the other 2, in the county of Fulton, state of Georgia, the 11th day of September 2013, did intentionally drive and steer a motor vehicle at, towards, and in the direction of E. Robertson L., a peace officer employed by Atlanta Police Department as a peace police officer who was at the time of the said assault, engaged in the performance of his official duties as a peace officer, said motor vehicle being a means likely to cause serious bodily injury when used offensively against a person. You see that?
Yeah, it's on paper.
Okay. And you were driving that 2004 Nissan Altima vehicle at the time that you almost killed Officer Robertson L., right?
I don't recall, sir.
Okay. You knew Officer Robertson L. before September 11, 2013, right?
I don't recall, sir.
And on this one count, you entered a plea under Alford, and we'll discuss what that means, 10 years to serve 3 years in prison, right?
Yeah, I don't recall it.
October 2015.
Yeah, I don't really remember anything.
All right, let's go to count 2. This charges, again, the grand jurors charge you, Mr. Murphy, Mr. Plethro, with the offense of aggravated assault against a peace officer. It gives a code section. You know what OCGA stands for?
No, sir.
You do?
No, sir.
Okay. For said accused, that's you, Mr. Plethro, Mr. Murphy, in the county of Fulton, state of Georgia, on the 11th day of September 2013, same day, did intentionally drive and steer a motor vehicle into and against the motor vehicle, which was then and there occupied by A.C. Booker Higgins, a peace officer employed by City of Atlanta Police as a police officer, who was at the time of said assault engaged in performance of his official duties as such peace officer, said motor vehicle being a means likely to cause serious bodily injury when used offensively against a person. You see that count?
And that's what the paper said.
And you pled guilty under Alford and were sentenced on that count, right?
No.
You didn't plead guilty
No.
to that count?
No.
Okay. Count 3. Grand jurors again charge you, Mr. Murphy, Mr. Plethro, with the offense of aggravated assault against a peace officer for said accused, county of Fulton, state of Georgia, on the 11th day of September 2013, did intentionally drive and steer a motor vehicle into and against the motor vehicle, which was then and there occupied by B. Porter, a peace officer employed by Atlanta Police Department as a police officer who was, at the time of said assault, engaging in performance of his official duties as such peace officer, and motor vehicle being a means likely to cause serious bodily injury when used offensively against the person. And you pled guilty to that and were sentenced, right?
I don't remember.
Okay. Then count 4 is going to be no process against you, but the charge is that you, Mr. Murphy, and Mr. Plethro were charged with the offense of armed robbery for that you all, in county of Fulton, state of Georgia, the 11th day of September 2013, did unlawfully with the intent to commit a theft, take from the person and immediate presence of Derek Dotson, United States currency, the property of Derek Dotson by use of a handgun, an offensive weapon. That case for you was dismissed, right?
I don't remember.
Or no process.
I don't remember still.
All right. Mr. Kokomo, just go back to the very first page of State's Exhibit 157 for a second, please. And scroll down to count 4, 5, and 6. You see count 4, armed robbery, we just read, and then it says in the third column, disposition, no process. You understand that? The same with count 5 and 6.
That's what the paper says.
Okay. Let's go to count 5. What was dismissed against you? You were charged in count 5, along with Mr. Murphy and Mr. Plethro, with aggravated assault with a deadly weapon for said accused in county of Fulton, state of Georgia, on the 11th day of September 2013, did unlawfully commit an assault upon the person of Derek Dotson by shooting at, towards, and in the immediate direction of Derek Dotson with a handgun, same being a deadly weapon. Your case was dismissed. That's what you were charged, right?
Yes, sir. The paper say.
And then count 6 is going to be the grand jury's charge you, Walter Murphy, and Mr. Plethro with the offense of possession of a firearm during the commission of a felony for that said accused, the 3 of you, in the county of Fulton, state of Georgia, on the 11th day of September 2013, did unlawfully have on and within arm's reach of accused person a handgun during the commission of a felony against and involving the person of another, to wit, armed robbery, and that case against you was dismissed, right?
That's what the paper say.
Okay. And then number 7 charges just Mr. Walter Murphy with possession of firearm by convicted felon. Count 8 charges Mr. Plethro, possession of firearm by convicted felon. And then count 9 charges you, Mr. Murphy, and Mr. Plethro with the offense of fleeing or attempting to elude for that said accused, County of Fulton, State of Georgia, 11th day of September 2013, did willfully fail to bring his vehicle to a stop after being given a visual hand signal to do so by E. Roberson L., a police officer employed by Atlanta Police Department in uniform, prominently displaying his badge of office in an appropriately marked police vehicle. And you pled guilty under Alford to that, right?
I don't remember.
The next page has, again, your name, your date of birth, has 6/22/79, and then Mr. Murphy and Mr. Plethro's information. And then if you go down to the witness list, you see the witnesses, Derek Dotson, and then the police officers, including Detective Quinn. You see that?
Yes, the paper say.
Okay. Now, that same day, you disposed of another case. You remember that?
No, sir.
Your Honor, may I approach?
You may, sir.
May I approach you? I'm showing you what I've marked as dated today, Mr. Williams, number 199. You can look at the whole document, okay? I'm not trying to rush you. Tell me if this is your signature.
No, sir. I didn't write that.
I'm sorry, number 2.
I didn't write that.
Okay. Is that your signature?
I didn't write down one of them.
Is your lawyer, you recognize the signature of Ed Adams? That's your lawyer?
I don't know how his signature would be, sir.
Is that your lawyer?
Yeah, that was my lawyer, but I can explain to you about his signature.
Okay. And do you remember being charged and convicted of aggravated assault with a deadly weapon for an incident on September 7, 2012, did commit an assault by shooting of a person named Cameron Randolph? Do you remember that? I can't hear you.
No, sir.
You deny it.
I mean, if that what the paper said, I don't remember that. I don't remember the name back then.
Do you remember being charged in count 2 with aggravated assault with a deadly weapon on the same day, September 7, 2012, by committing assault on James Butler by shooting James Butler?
No, sir.
You're denying that.
Yes, sir.
You do realize you're on an oath.
Yes, sir.
Okay. Remember count 3, being charged and convicted of possession of a firearm by a convicted felon on the seventh day of September 2012, did knowingly and unlawfully.
I don't remember that, though, still.
You had a firearm, to wit, a handgun. You were a convicted felon from indictment number 01-SC-03786, Superior Court, Fulton County, charged with possession of cocaine with intent to distribute on May 18, 2021. Are you denying that?
Sir, I don't remember that, sir.
And then on the last page, it has, again, your name and your identifying information, including 6/22/79 is your date of birth, right?
That's what the paper say.
Your Honor, I have a certified copy of a conviction from the Honorable Fulton County Superior Court Clerk for State of Georgia versus Mr. Adrian Bean, same lawyer, same date, judge down. I have the plea colloquy if you want it. And in fact, I have the same date of birth on the document itself, and I move it into evidence.
Have you shown that to the state? What
Of
are you
course.
marking there, sir?
Mr. Williams, number 199.
Any objection to Mr. Williams 199?
state has no objection to the self-authenticating document that is the certified conviction, that is Williams 199. I'm not certain what the rest of Mr. Steele's representation is regarding the colloquy, but the certified conviction, the state has no objection.
All right, I'll admit, Jeffery Williams, 199, the actual certified copy of the conviction. The other allied documents can be separated, okay?
Your Honor, may I approach Mr. Bean with Mr. Williams, number 199, that's in evidence, as well as states 157C, in case he needs to refer to them.
Yes.
May I approach you again?
I don't care. What?
Can I?
Yes, sir.
I'm showing you, and I'm going to leave with you, in case you need to see them, just let us know if you're looking at them. This is Mr. Williams, number 199 in evidence. This is State's Exhibit number 157C. Okay. With Mr. Kokomo's permission, Your Honor, I would like to show on display Mr. Williams, number 199, that's now in evidence.
All right, may be shown.
Okay, Mr. Bean, we are looking with Mr. Kokomo's permission at Mr. Williams number 199. It's on the screen. It's also right in front of you. If that's easier for you, you could look at either one. And at the top of that, on the left-hand side, again, it is State of Georgia versus you, Adrian Bean. You see that?
Excuse me. Can I say something?
Not really. Answer my question, and then you ask the Honorable Court.
Is that what the paper say?
What'd you say, sir? I'm sorry.
That's what the paper say?
And then this is for indictment number. You see under it, criminal action number 14 SC 1306, 0460. You see that?
Yeah, that's what the paper say.
All right. And Mr. Bean, to the right of that, you see in that rectangle, it's the same date of birth for you, 6/22/79, right?
6/22/1979 has been stated to be my birthday. Yes.
Okay. And then underneath it, we are going to go to the charges. You entered a plea. It says a non-negotiated plea. You see that check mark right in the center top? Or it's not a check, it's an X.
That's what the paper say.
Okay. And then a little down, you're charged now in 4 counts in this indictment. And the first one is aggravated assault with a deadly weapon, as well as is the second count. The third count is possession of a firearm by a convicted felon, and the fourth count is possession of a firearm during the commission of a felony. You see that in the second column on the left?
That's what the paper says, sir.
And then in the center, well, it's center left. You see the disposition? You again entered a guilty plea under Alford. So all 4 counts. You see that?
That's what the paper say.
And then next to it is your sentence. And you see the sentence now is 10 years to serve 3 years, balance of 7 years on probation. And that's to count 1 as well as count 2. You see that?
That's what the paper say, sir.
And then on the far right-hand corner, that says concurrent with the indictment number, which is in State's Exhibit number 157C, as in Collette, indictment number is 13 SC 12207. You see that?
That's what the paper say.
And then for count 3, and you get 5 years to serve 3 years, balance of 2 years probated. You see that?
Yeah, that's what the paper say, sir.
And that's concurrent with count 1 as well. Right?
That's what the paper say.
Okay. And then on the last count, it says 5 years to serve, suspended, consecutive to count 1. You see that?
Yeah, that's what the paper say.
And consecutive, means run after.
right?
I don't know what the consecutive means, sir.
All right, well, the sentence summary, if Mr. Kokomo goes down. The summary is that you, the defendant, is sentenced for a total of 15 years, the first 3 years to be served in confinement, the remainder to be served. And then if you go to the next page, at the very top, you are to receive credit for time served in custody as determined by the custodian. And then number 2 is checked. Upon the service of 3 years in prison, upon the service of 3 years, the remainder of the sentence may be served on probation, provided the defendant shall comply with conditions of probation. And when you go down, Mr. Kokomo, they're going to be the same conditions that we discussed earlier for your other conviction in State's Exhibit 157C. You see that?
If that's what the paper said.
All right, and then if you go down to the date, keep going down, please. And there again, you're represented by your lawyer, Ed Levance Adams, by employment, and that's ordered the 14th day of October, 2015. You see that?
That's what the paper said.
The next page is going to be your indictment. And this is 14 SC 130460, charging you, Mr. Bean, with those 4 counts, 2 counts of aggravated assault, possession of firearm by convicted felons, count 3, possession of firearm during the commission of a felony. This indictment was returned on October 24th, 2014. You see that?
Yeah, that's what the paper says, sir.
And underneath that, it is stamped there, October 24th, 2014, same day the grand jury returned the indictment. And if you go down, you had first, on December 22nd, 2014, entered a not guilty plea, and that's on the left-hand side with your lawyer. And then in the middle of that page that Mr. Kokomo is showing, you change it to a guilty plea under Alford versus North Carolina to all counts on the first day of October, the 15th day of October, whatever that says, 2015. You see that?
Yes, sir.
And then you see underneath it's filed in the office of the clerk of Fulton County Superior Court on October 15, 2015, the same day as you were sentenced on the other September 11, 2013 crimes, right?
That's what the paper says.
And then on the next page, it shows the grand jurors charged you, and then in count 1, this indictment is only you. You're the only person in it, right?
How many times we're going to look at it?
One more time.
How many times we're going to keep looking at the same paperwork?
You're the only one charged, right?
I ain't charged. I mean, how many times we're going to keep looking at the same paperwork that you're showing me?
You're the only one charged. Answer the question, please.
That's what the paper says.
And then it says in count 1 that the grand jury does charge and accuse Adrian Bean with the offense of aggravated assault with a deadly weapon for that said accused, County of Fulton, State of Georgia, the 7th day of September 2012, did unlawfully commit an assault upon the person of Cameron Randolph by shooting him with a handgun, same being a deadly weapon. You see that?
That's what the paper says.
Count 2 that you pled guilty to under Alford charges you with the offense of aggravated assault with a deadly weapon for said accused in the County of Fulton, State of Georgia, on the 7th day of September 2012, did unlawfully commit an assault upon the person of James Butler by shooting him with a handgun, same being a deadly weapon. You see that?
That's what the paper says.
Now, this is approximately 4 days short of a year from then is September 11, 2013, when you were driving that red 2004 Altima, right?
I don't recall still.
The next,
Sorry to hear the response.
I don't recall still.
the next count is count 3, charging you with possession of a firearm by a convicted felon in County of Fulton, State of Georgia, on the 7th day of September 2012, did knowingly and without lawful authority possess a certain firearm, to wit, a handgun, accused having been convicted of felony on indictment number 01-SC-03786, Superior Court of Fulton County, charge of possession with cocaine with intent to distribute on May 18, 2021. Right?
That's what the paper says, sir.
That's about 11 years earlier than September 2012, right?
I guess that's what the paper say.
And you told the jurors that you've been through the prison system several times. Didn't you say that today?
Today?
Didn't you say that?
I said I've been in prison before.
All right. And then count 4 charges you possession of a firearm during the commission of a felony for that it says accused, excuse me, in the County of Fulton, State of Georgia, on the 7th day of September 2012, did unlawfully have on and within arm's reach of accused a person a handgun during the commission of a felony against and involving the person of another, to wit, aggravated assault, and you pled guilty to that, right?
I don't remember.
All right. And then on the next page, it shows the witness, it shows your name and information, or some information, again, giving your date of birth as 6/22/79, and then the witness list against you. And you see that Mr. Billingsley, Mr. Butler, Mr. Randolph, and then those police officers. You see that?
Yeah, that's what the paper say.
All right. Now, Mr. Bean. I noticed several times on last Thursday and Friday that you were given a choice. Is your answer you do not recall information on statements that you gave on recording to Detective Quinn on September 17, 2013, or are you saying you did not do that? Do you remember that?
Yeah, I don't recall.
And you specifically never said that you denied that it occurred. You just kept saying, I don't recall. Remember that?
That's what I said.
Now, you know and remember September 11, 2013. The I don't recall is not true. You are not being honest to the jurors. Am I right?
I don't remember, sir.
Do you recall meeting with me and investigator James Martin, private investigator, and we were trying to get in touch with you, and we caught up with you on Sunday morning, approximately 11 o'clock in the morning, on January 22 of 2023. You remember that?
Yeah, I don't really remember, though.
Do you remember saying, because we were in front of your house, I'll speak with you, but let's go to the nearby Kroger. Remember that?
Something like that. I mean, I don't really remember the conversation, though.
Do you remember Investigator Martin and me asking if we can record the conversation with you?
Okay.
Do you remember giving permission and said, that's fine?
Okay.
Do you remember me telling you, I only want the truth?
Okay.
Do you remember?
Your Honor, as to this.
You have an objection, madam?
Objection as to
Basis?
hearsay, the questions have been posed.
I think he's going to ask them, so at least, is that your intent, Mr. Steele?
I have to lay the foundation.
Your Honor, I'd like to approach us to the foundation.
Work goes smoothly when you know the right steps. With Asana, you can coordinate tasks across teams and stay on track, so your team can spend more time celebrating wins.
right, ladies and gentlemen. Oh, it's not church yet. Come on now, stop fanning, all right? Okay, all right. Not that hot. All right, ladies and gentlemen, we are going to take a comfort break, and then we're going to go ahead and take lunch, okay? So we'll come back for 2 o'clock. We're going to go about an hour at that point in time, and then that'll be the, I'll make some administrative announcements at that point in time, okay? All right. So remember the admonitions I've given you. Enjoy your lunch. We'll see you back at 1 o'clock. I should say 2 o'clock. Okay. All rise. Where are you going? Oh my God. Enjoyed those immensely. Oh, I could have. They're like, I could have eaten those all afternoon. All right, ladies and gentlemen, please be seated. The door, Deputy, can you get Mr. Bean, please, sir? Thank you. Mr. Bean, just hold fast, stand fast. I'm going to release you for lunch. Come back for 2 o'clock. I'll be back here just a little before 2. Don't discuss testimony with anybody except the attorneys in this case, okay? Okay, see you then. All right. Councils, we're gonna be in recess until 2 o'clock. Can I see Ms. Love and maybe Mr. Steele and Mr. Matthews? Can you all come up for a second, please? All right, we're in recess.